Good afternoon, everyone. My name is Christine Hausler, and I lead the Center for International Law here at the British Institute of International and Comparative Law. And it's my great pleasure and honor to welcome you all today for this event. Welcome also, of course, to all of you who are listening online. It's really a pleasure to host this event today. I will let Catherine Amirfar formally introduce Judge Joan Donoghue later on. But I do want to say one word of welcome, of course, on behalf of everyone here at the Institute, because you may have seen the announcement last week that Judge Donoghue has become Vice President of the Institute. So a very warm welcome. Everyone here is extremely excited, and we are sure that we will very much benefit from your experience and expertise. So a big welcome in this Bickel family, if I may say so. I now would like, of course, to welcome very warmly Catherine Amirfar today. She'll be in conversation with Judge Donoghue. She's a litigation partner at the Beauvois, which she first joined in 2002, but she's actually had a very varied career. She's also worked at the US Department of State, where she received the Superior Honor Award. So she's very well recognized, of course, as a top practitioner in international law. So we're very pleased to have her to lead this conversation today. And it's, of course, quite fitting. She's appeared in front of many domestic courts, international courts and tribunals, including the International Court of Justice, of course. There's one also aspect of her career I'd like to highlight here today, because we are the British Institute and it's a registered charity, and Catherine has done a lot of pro bono work. I'm not sure how she does it, but apparently she continues to do so, to advise NGOs, to advise individuals, principally on human rights matter. And that's something, of course, an aspect of her work that we very much value here at the Institute. Now that, of course, leads me to thank very much the Beauvois for supporting us tonight, for hosting this event. That means we can host it free of charge. That means that you will have also a reception that will be hosted on the ground floor just after the conversation. So please do stay with us and join us at the reception. And more in general, I'd like to thank the Beauvois and Plimpton, because not just for their support tonight, but for the engagement with the Institute throughout the year. We've had several conversations with partners at the Beauvois, with associates, as to how we can strengthen our international law work. And that has, for example, led us to establish a practice fellows initiative that has just started this year. So we thank them for this ongoing conversation and look forward to working more with them in the future. And now, last but not least, I would also like to thank the Dorset Foundation. The event is part of the Harry Weinrebe Memorial Lecture. Harry Weinrebe was a philanthropist, and he established the Dorset Foundation. We're very pleased that they have actually agreed very recently to renew their support of the Institute for our international law work. That allows us to strengthen our work, to disseminate our research more widely. For example, over the last year, we've established an impact hub that has meant that a lot of our researchers managed to spend some time to, for example, submit some of their research to UN special procedures. And recently, quite a few of them have been utilized in those annual reports that have been submitted for the General Assembly. So we're very pleased that they allow us to strengthen our international work further. But that's enough for me, and I will hand it over now to Catherine. Thank you very much.
Thank you so much. And Kristen, thank you so much for all that you've put into this. And a huge thanks to Bickel for hosting this. It's nothing but a pleasure. And to be here with Joan, who, she won't like me saying this, an icon in international law, is a particular pleasure. So welcome, everybody. We're looking forward to the conversation, and thank you for being here in the room. So I'm going to start with introductions, and, you know, Joan, I could go on, but I did pick out a few things here and there that just struck me about your remarkable profile. So obviously, International Court of Justice from 2010 to 2024, serving as president of the court in the last 3 years. The fourth woman to be elected to the ICJ, the second woman to hold the post of president. And before that, this really remarkable and illustrious career at the US State Department, where she was Principal Deputy Legal Advisor from 2007 to 2010, Acting Legal Advisor in 2009, including in advising then Secretary of State Hillary Clinton and President Obama on all aspects of international law. And when I looked at the matters, Joan, that you touched on, I mean, I know in our world now we tend to specialize, but I'm just going to give you a taste of what Joan touched in her portfolio at State Department. So, advice in relation to the Kosovo AO, supervision of U.S. advocacy before the Iran Claims Tribunal and NAFTA tribunals, transition to democracy in South Africa, advice on BIT negotiations, negotiations of the UNFCCC, negotiations of the Antarctic Treaty, various issues involving head of state immunity, part of the U.S. team in Nicaragua, the U.S., advisor in negotiations on alternatives to the Panama Canal. I'm just naming a few. Truly remarkable. In 2009, was given the Distinguished Honor Award. Is that better than the Superior Honors Award? I'm jealous, which is actually the highest award from the U.S. Secretary of State. And in Joan's free time, she studies Arabic, Russian, Spanish, and French. Currently the honorary president of the American Society of International Law. Bickle, we had her first. And most recently will join the law faculty at Cambridge as the Arthur Goodhart visiting professor. Joan, a very, very warm welcome. Thank you so much for being here with us. So as you all know, the topic here today is the challenge and future of international adjudication. Obviously a big topic, lots to say on it. I'm going to start with some table setting, and then we're going to really delve into the details. And I told Joan I was going to do this, but I'm going to quote her for over the years and ask her about a sense of evolution in her thinking. But I'm going to start, Joan, with your 2012 Law Review article. And that was written right after you began your tenure at the court. And you wrote, and I quote, "The ICJ has its roots in the notion that adjudication in a world court can serve as an alternative to war." And with that starting point, you went through the unique role of the World Court, really, I think, in trying to explain that unique role in the context of the Pacific settlement of disputes. And in that context, you referred to, and I'll quote you again, the potency of the court. And you said, "I chose that word deliberately because a medicine can be potent, but so can poison. There are observers who would label the court as one or the other." 6 years later, in your 2018 Grotius lecture, this was at ASIL, you focused on what you referred to as, again, to use your language, peaks, valleys, and rolling hills of international adjudication. And you went through a summary of, I'd say, aspirations, disappointments with the court. I think you talked about one valley being, for example, the lens of states accepting compulsory jurisdiction of the court, which is an issue that we'll come back to. And at the same time, of course, you've been a powerful voice in support of the court and what it could do in contribution to peace building. So I'll go and speak now, obviously, in the world that we're living in, thinking about the court as an antidote to the resort to the use of force in the Ukraine, in Gaza, and sitting here today, we're all very aware of the enlarging war in the Middle East. All of this is on the uptick. Last year at a meeting of the UN Security Council, Secretary General Guterres warned that the court is at, quote, the world is at grave risk of lawlessness. And what I thought was significant is that he said, in a signal of the enduring faith in the court, specifically urged the safeguarding of international law and international rule of law by urging states to have greater acceptance of the court's compulsory jurisdiction. So he linked those 2 points. And it is true that notwithstanding the tepid uptake on compulsory jurisdiction, the court has never been busier. And I'll end with just saying that in your address to the UN General Assembly last year as president of the court, you noted the court had a docket of 18 contentious cases, 2 advisory proceedings involving, and in your words, states from all regions of the world that present questions of international law that concern all of humanity. So there's a lot there, right? And I wanted to turn it over to you just to set the stage in that context, in your thinking, in your evolution, in your writing, and your speaking. But over to you.
Thank you, Catherine. I asked to have the mic placed on the table, but the people at the back of the room need to tell me whether they can hear me. Any complaints? No complaints. So if that changes, wave your hands or something. And you heard Catherine's very kind introduction. which probably made you wonder whether the Debevoise reception is a breakfast reception tomorrow morning, because there is a great deal to cover. But before we turn to that, I just want to thank Kristen for her kind introduction, Catherine as well for hers, Bickle for giving me the opportunity to join as vice president and to be here tonight, and all of you, whether present here in London or listening from some other place, for taking the time to participate here. Also, thank you to the Dorset Foundation for its general sponsorship of Bickle and for this lecture series in particular. So Catherine mentioned some earlier writings of mine, which she had warned me about, which gave me a chance to think about what I had said. In 2012, I spoke at the University of Georgia, and it was part of a series of trips I took with the then executive secretary of the American Society, which I called privately my Red State Tour, because I was mostly going to places in the United States where there was somebody active in international law, but the community was one that was not necessarily likely to be interested in international law or aware of it. And I was trying to talk about why they should care about international law, but also to try to hear what they had to say, to try to engage with some of their doubts. And so mostly what I was focusing on there were critiques by right-wing observers about the court, which essentially were focused on the idea that this court had too much opportunity to constrain U.S. sovereignty. We've heard a lot more about that since 2012, of course. Well, 6 years later in 2018, when I spoke at the American Society, I was still focusing on criticisms, but more on criticisms coming from inside of the international law community, because by the time we got to 2018, we had a lot of courts functioning. The ICC in particular was kind of up and running. And we started to see more and more criticisms from within the field about what was wrong with those courts, how they weren't meeting expectations, how they were disappointing. And that's what led me to say that, to observe that we often started our ideas about a new court with lofty aspirations. Then it turns out it's actually hard to do these things. So there would be disappointments and complaints, which I described as the valleys. And I said, essentially, this stuff is hard. It's hard to convince states to subject themselves to compulsory and binding dispute settlement. It's difficult for them to stay the course if they're not happy with an outcome. And essentially, we in the field simply have to recognize that this is work that's important and that will always be a hard slog for all of us in the field. Now, 6 more years, here we are today. And as Catherine mentioned, the state of the world is perilous. I would say for me, I really pause every time I open the BBC app on my phone these days, because pretty much never read anything that looks better these days. And in the meanwhile, we hear lots of complaints about the dysfunctions in the so-called international system, especially in the institutions in New York associated with the UN. So on the one hand, it's true that the court is busier than it ever has been, and that many of the cases before it place before the court important conflicts that are getting a lot of attention outside of the court and that have dimensions far beyond those that the court has scope to address. So I think a key question for us to discuss as we dig into some of the details is, what role can the court really be expected to play in these current circumstances? And I look forward to talking about those topics and certain aspects of them this evening.
Thank you. So let me pick up on one strand, which is that this stuff is hard, and start with one of the hardest contexts, which is these very complicated geopolitical crises. We seem to see a proliferation of them. And by complicated geopolitical crises, and we ask ourselves, what's the role of international adjudication? We also have to think about the contours of these crises really defy categorization in a single subject matter. They defy the ability to go to a court of general jurisdiction, especially, again, given the waning of states taking up the general jurisdiction of the ICJ. And so what you do have is courts and tribunals picking up aspects of the crises within their jurisdictional remit. So a situation where you can have multiple courts and tribunals treating the same crisis, but treating it in the sense of different aspects, different legal lanes. And I think we talked about this in the lead up to this in the 2023 LaLeve lecture. I called this the mismatch between jurisdiction and the underlying geopolitical crises. But notwithstanding that terminology, didn't consider it a negative. And what is the role for international adjudication when you don't have a court of general jurisdiction to handle all aspects? And in my view, and again, we talked about this, there is a role. And the example that will still be relatively fresh, I think, in the minds of this audience is the one of the blockade imposed on Qatar in 2017 by Saudi Arabia, Bahrain, Egypt, and the UAE. And in that context, it was a complicated geopolitical crisis. There wasn't a court of general jurisdiction that could deal with all aspects of the crisis. And so what happened were 14 separate proceedings, 3 ICJ proceedings proceedings before treaty bodies. There were investment arbitration proceedings. There were an extraordinary number. And those proceedings taken together ultimately contributed to a solution, a universal settlement that ultimately extinguished all claims. Now, there's one example. There's an upside in the sense of taking the energy out, if you will, of contributions, energy out of a dispute in terms of contribution to armed conflict. At the same time, there's a risk that we all know very well of fragmentation. And I think this idea or this push and pull is ever present. And we obviously have a situation where the court's docket is not getting easier. You have, for example, the climate change advisory opinion that's coming up in the oral proceedings starting in December, in a situation where ITLOS, for example, has given an advisory opinion over at least the UNCLOS aspect that is also before the ICJ. So that's a long way of asking you the question of, with this proliferation, with this of geopolitical crises, international adjudication, how do you think that the court or we should think about the balance between the tug and pull of that?
Well, thanks for that question. Obviously, this mismatch, as you describe it, is there. And I don't think we're going to see 193 acceptances of ICJ jurisdiction anytime soon. So it's there on an ongoing basis. I actually think it's a bigger problem for the states involved in a conflict and those advising them than it is for the court. And that's maybe because the court really can't and shouldn't try to manage these various disparate other bodies. It doesn't have the reach to do that, the scope to do that. So judges are aware usually of other proceedings. And certainly if a party thinks that its position before the court will be advantaged by hearing about other proceedings, you can count on the party to make sure the court learns about that proceeding in detail. But in general, the court is aware that there are these other proceedings out there. Maybe they're parallel, maybe they've already taken place, maybe they're on the horizon. And it looks at its task, whatever its scope is, the asserted scope of jurisdiction, and then makes a decision whether it has jurisdiction, and really more or less keeps in its lane, I think. But I would say, if you look more generally at the way that the court engages with pronouncements by other courts and other bodies that are addressing relevant facts or legal pronouncements, that the court, I think in past decades, was probably seen as a court that considered it unnecessary for it to pay much attention to what was being said elsewhere. And that has changed in recent decades, certainly since I joined the court in 2010. The court is more comfortable citing quite frequently authorities from other sources, other courts and other sources. But it, of course, always guards its own freedom to make its own decision. And I'd say, if you look at the way the court approaches what's said elsewhere, there is greater use of and reliance on conclusions of law or conclusions of fact in particular, if the process that led to those conclusions is one that is clearly robust. And so the best example is that the court made great use of factual findings by the ICTY in relation to the former Yugoslavia, and used those findings in the cases that the court then had. So those were findings that emerged from a robust criminal law proceeding. Whereas sometimes there are statements of law or assertions about the facts in an ongoing crisis that emerge quite abruptly from, say, for example, some special rapporteurs. And in that case, the court, of course, has to give less weight to that kind of a pronouncement, however attractive it may seem, or however much a party wants to push it forward, because it doesn't stand on its own two legs the way that something that results from a robust process might.
So I guess there would be a forward progression in terms of the openness and receptivity, but still very careful and rigorous and a look at what underpins the other proceedings. Is that fair?
Yeah, I think that's fair. And I think also that, an awareness that there are these previous or upcoming or parallel proceedings in place, but generally the awareness doesn't stand in the way of the court doing what it's tasked to do. When proliferation was getting so much attention, the question was posed, well, what can be done about it? And I think ultimately the real problem only arises, it seems to me, if you have the same facts brought to two bodies where the allegations are the same breaches of law, the same treaty provisions, et cetera. And in reality, maybe that has happened a few times, but that doesn't really happen. So this fragmentation that we really see is that energetic efforts on the part of states in a conflict to find places to move forward parts of their dispute lead to multiple proceedings, but proceedings that belong in different places in the fragmented system that we have.
Thank you. Let me pivot now to, I think, a point that'll be top of mind for us, which is erga omnes and erga omnes partes obligations, which I know is also very much of interest to you. So in the words of the court in Barcelona Traction, these are the obligations that are owed to the international community as a whole in view of the importance of the rights involved. So a lot of obvious obligations around genocide, torture, fundamental human rights would fall within the ambit. Now, I'd say that the court opened the door in Belgium v. Senegal to what some would view as an expanded concept of standing in service of some accountability. I'd say it's fair to say accountability around human rights abuses. In the words of Judge Ware-Montry, where the allegations implicate greater interests of humanity and planetary welfare that transcend the sphere of bilateral relations. So that's the underpinning and conceptual framework. On the other hand, some have suggested that erga omnes and erga omnes parties standing is very broad. It risks proliferation and already would, I think, perhaps inefficiently contribute to the court's docket. So what do you think? Is there merit to the criticism? How might the court strike the right balance between those 2 points?
Yeah, thanks for asking the question. Of course, I'm tempted to turn it over to Judge Greenwood, who's here in the audience and was there also when Belgium-Senegal, when the court delivered the judgment in Belgium-Senegal. Legally, I think it's clear that the decision there was correct. That if
Good news.
if a so I'll spare Judge Greenwood. So if a particular obligation in a treaty has an erga omnes character, then the court, I think, is correct in saying in that case that the rights and obligations run between or among all parties to the treaty, and therefore any party has standing. It's also correct, and as we've seen recently, that this does create more opportunities for cases to be brought to the court and for applicants to overcome the standing hurdle. I think some details get lost, especially when commentators write about this with great enthusiasm. And the two that come to mind are, first of all, that even if a treaty is a human rights treaty, and we think of many of the core obligations as having an erga omnes partes character, doesn't mean that every single provision in that treaty has an erga omnes partes character. There might be some that remain exclusively bilateral. For example, if the provisions are worded such that they channel the procedures of extradition into a bilateral process. In addition, we don't yet know how the court will approach the questions of erga omnes standing in respect of treaties that it hasn't addressed yet, and that remains to be looked at. So we'll see how that develops. But I think two other points need to be borne in mind, and they basically arise from the fact that this is only about standing. So when an applicant comes to the court, it still has to satisfy the court in relation to jurisdiction in all of its aspects: subject matter jurisdiction, jurisdiction in personam, temporal jurisdiction. But then beyond that, suppose that the applicant survives questions of jurisdiction and admissibility and gets over the standing hurdle, then it has to prevail on the merits in order to succeed. And we'll see how that plays itself out in cases in which an applicant is remote from the constellation of facts that gave rise to the dispute. Will that applicant be well positioned to provide supporting evidence, for example? So yes, the decision, while legally correct, has led to a larger number of cases being brought. Where that will lead ultimately, say 10 years from now, remains to be seen. And I think it's a good thing to continue to be thinking about, both for the court and for those who are active in appearing before the court.
Thank you for that. So the door is open, but states would be wise to remain, cognizant of all of the other requirements that must be met. So let me switch to an easy topic: provisional measures. So obviously on the uptick, obviously it puts the court front and center in some of the most sensitive, urgent disputes known to the world, for good and for bad, I suppose. And we can talk about where you think that balance is. But it's safe to say that provisional measures have become a regular fixture in the court. I think it's also safe to say that provisional measures have become a regular fixture in the strategy of states when they think about why take a dispute to the court. It involves years, it involves lots of investment of resources, time, attention, money, but it is certainly part of the strategy. So I wanted to talk to you about what are some of the short-term objectives versus the medium to long-term objectives, and how you think states should weigh the pros and cons of including a request for provisional measures in a given case, of seeking more provisional measures once they've instituted and already made one request. How should applicant states orient around requests for provisional measures?
Well, if I were president, I would probably say, please don't ever file any more. And
An honest response.
My partner, Julie, who's here today, would certainly agree with that. When I was president, and my secretary would say, the registrar's calling, no matter what, the first thing I would say when I picked up the phone was, Philippe, please don't tell me there's another provisional measures request.
On a Friday night at 8 p.m.
To put this in context, the term of a president at the ICJ is 3 years. So in the 9 years before I became president, there were 3 presidents. And during those 9 years, the same number of provisional measures orders were delivered as I delivered in my 3 years as president. And the court was busy with other things. So the overall effect on the court of the uptick in provisional measures requests is substantial. The court is required to give those priority, which means that other matters that may seem urgent to the applicant, for example, or the big advisory opinion requests that have been pending, one of which has been decided, for example, those get pushed back in order to handle provisional measures requests. And of course, it's not just the few hours at the hearing. It's all the other preparatory work and the drafting, et cetera, that goes into the requests. So how should states weigh things? Well, a great deal of that, I think, is probably something you might wish to speak to, and I'll give you back the floor perhaps. But I would say that it is very important for states to think about the short-term advantages they might gain versus the longer-term costs and downsides. Sometimes I've wondered whether a state that has brought a provisional measures request might later think it prudent to withdraw the case entirely after they've gotten what they've gotten. But then if they do that, they will be characterized by the other party as having given up their case.
Yeah.
So that's probably not a viable option for them. But in general, when a state comes to the court with really excessive requests that have no realistic prospect of being granted, or requests that could be compelling but are poorly supported, it doesn't start off on a strong footing before the court. So even if that might create an opportunity for some news, some publicity, so a public forum where the grievances are expressed and easily available, for example, on video. There are reasons to be cautious about that, I think, because it's not in the state's interest to kind of a bad taste with court. And equally, I would say there may be very good reasons why a state comes back and asks for more measures. That's available to them, certainly. But again, once again, some caution is necessary because of the potential downsides. You've obviously been in these kinds of conversations, and if you have anything else you want to add, please go ahead.
Thank you for that. Look, I would say it's very rare these days where provisional measures don't play some role in conversations with states about whether or not they invest the time and energy in bringing a case to the ICJ. And I think by sheer virtue of the structural limitations on getting an answer to what is often a very sensitive, very high profile dispute for that state in the years that it takes for the court to properly adjudicate, the provisional measures are seen as a potential way and tool for as a political lever in some instances to deal with the urgent and sometimes not so urgent aspects of the underlying crisis. I don't say that pejoratively. I don't think it's necessarily a negative, as long as you say, counsel are very careful to advise states to make sure that there is an appropriate basis for bringing the measures. I think one of the worst things you can do is, a disservice to the case, is to come in with your application and then have a very weak request, which gives the sense of trying to instrumentalize the court in some fashion just to, hit the airwave, so to speak. So I think it must be very careful, but at the same time, it also keeps the court relevant, doesn't it? It keeps the court in the midst of pacific resolution in a very time-sensitive way. And so I think of that lever as an important one. And it's going to continue to be in a conversation with states, and urging caution is, I'd say, what counsel have to do. And it's not easy. And a win or loss of provisional measures can completely take all the oxygen out of the room. And sometimes the merits conversations are left to the side, and you can't do that as counsel. So I would say that I think it is a tool. I appreciate the proliferation point, but I do think of it as a continuing vibrancy of the court in dealing with urgent disputes. So, but I completely appreciate what it does to the court's docket. And the court has remained remarkably responsive. I mean, I think that you may know the stats as president better than I, but 4 weeks it's very quick turnaround, and it does go straight to the top of the docket, and the court deals with it, I think, in an incredibly substantive way. So I'm sure there'll be more questions on provisional measures. So again, another pivot, I want to talk about technical and scientific evidence. I'm clearly not giving you a break. At some point, I'll ask you what your favorite color is, but not yet. All right, so technical and scientific evidence. I think careful watchers of the court will appreciate that for many years, over a decade, the court has gotten some criticism about the way that it handles technical scientific evidence, the sense that it's too much of a superficial touch. And the court has taken steps, I would say, in the last decade, in recent years, to engage more fulsomely with technical and expert evidence. And that includes, I think, in the Whaling case stands out as an example of the court in conducting cross-examination. You pointed out the judgment relies extensively with graphs in the judgment itself around that technical evidence. So there's obviously a lot of engagement. There's the appointment of Article 50 independent experts. Congo v. Uganda is a very good recent example of where the court appointed experts delved very deeply into the scientific evidence and, again, engaged. So we do have what I'd call that trend line. We also have the continuing criticisms. We have the extraordinary challenge, and the court's not unique in this, but the extraordinary challenge of living in the digital age, in which the very nature of the evidence, evidence from the internet, where AI capability, deep fake capability, makes the ability to test digital evidence all the more challenging. So I guess the question for you is, do you think the court has risen to the challenge of dealing effectively with scientific and technical evidence? And is there room for more innovation in that area?
Yeah, thanks for that question. It's important to start by saying that whenever we talk about evidence, we're talking about the role of the International Court of Justice as a first instance court. And, when I talk to law students, especially, or recent graduates, in law school, what one studies in relation to the International Court of Justice is its substantive jurisprudence, so its pronouncements on international law. And it's easy to forget that this isn't a Supreme Court that's reviewing facts found somewhere else. But actually, it's a group of 15 judges that are assessing collectively questions of evidence. And so these questions about scientific and technical evidence are ones that especially bring to the fore the differences in approach on the civil law and common law sides because of the differing options for expert evidence, whether the experts should be brought into the proceeding each by a party, as is usually the case in the common law, or should be appointed by the court, as would typically be the case in the civil law. And the court has scope to do either one. I would say that within the court, when the questions are discussed, one typically sees at least the initial starting points of judges aligning to an extent with this, whether they come from a civil law or common law background, although the court has done both. Typically, if the parties put experts forward, the court is satisfied to rely on those. It's more common to just do that. In the case of Congo, Uganda, we might ask ourselves a little bit about what the court needed to decide there. And there, this was a case involving the valuation of damages caused by one state in an armed conflict with the other. Very, very difficult valuation exercises in terms of methodology and lack of new or reliable evidence. And so the court retained experts on such questions as how to value the minerals and other natural resources. And there, one reason why it was important to retain an expert there is that the specific question that was being asked of the expert, which is essentially, how do you value these lost resources, was the question that the court had to deliver an answer to. We had to decide how much compensation was owed by one state to another. But it's often the case that when a case involves scientific or technical issues, it's not incumbent upon the court to pronounce directly on whether such and such is a scientific fact or not. And what you typically see is that the court looks for opportunities to address those issues in another way. I wrote a short piece about expert evidence, and I drew on some scholarly research that referred to the idea of second order indicators. And what you see often for the court when it's grappling with complicated evidence like scientific and technical evidence is the court looks for indicators of whether the evidence is convincing without saying, we believe this is true or this is not true. So it looks, for example, at whether the methodology of the expert was seen as satisfactory by the other side's expert. It looks for concessions by a party, concessions against the party's interests. And it looks quite critically at the overall structure and organization of what the expert said. So it doesn't necessarily pronounce on the core fact, and it doesn't always need to pronounce on that. And I think that's relevant looking ahead to the climate advisory opinion. I don't have any inside information about what will happen in relation to that proceeding. But if you look at the question, you can see that it's a very heavy question loaded up with enormous number of issues. And the court will have to look first at whether it wants to reposition some of the questions that it's asked to address. And then I think also will have a chance to consider the extent to which it really wants to speak in its own voice about truly scientific or technical issues, or rather to refer to and make use of pronouncements by authoritative scientific and technical bodies elsewhere.
That's a very good example. And one aspect of the advisory opinion that I found interesting is that it's not quite the situation where the court has to choose between competing experts. And the one benefit of the IPCC is that we do have this ostensibly authoritative, international, state-driven technical process, but that the court can rely upon. So it may be that that's also something that would assist the court in not having necessarily to decide different interpretations of the same scientific body of evidence.
Yeah, just one more point on that. I think that the fact that you have these scientific and technical issues playing out in an advisory opinion proceeding also takes out of the court's menu of options heavy reliance on an adversary proceeding. So from the common law side, if we're looking at a contentious case, I would basically say, look, scientific evidence is the same as any other evidence. It's the job of the state is to convince me that its understanding of evidence is correct, convince me in a way that I can understand, even though I'm not an expert, and convince me in a way that I can write in a judgment in a manner that is comprehensible to somebody else. But once we shift out of the adversarial paradigm, that's not really available. And so the court has to look with more caution at what's being said about the evidence, I think, because you don't have that potential counterbalancing from the adversarial side.
So let me switch again, and I want to talk about something that I know is near and dear to your heart. And I'll start with quoting you again. So this is now, I'll take you back to October last year, before the UN General Assembly. You said, as part of your remarks, quote, "As the principal judicial organ of the UN, it is incumbent on the court to uphold the ideals of the United Nations in promoting gender equality and overcoming gender bias through the language it uses in its own official documents." And then more recently, and this was for the 75th anniversary of the ICJ, you've reflected not just on gender bias, but also brought in the dearth of representation before the court from developing countries. And I'll quote you again. You said, "Each time that I gaze out at the delegations representing parties, I am struck that their composition bears too much resemblance to the groups of persons who gathered in 1945 to draft the Charter of the United Nations and the Statute of the Court. Very few of the council are from developing countries, and almost all, regardless of nationality, are men." And in fact, there was, I think, many studies to this effect. I'll quote one, which was an EGIL study that it was issued at the end of last year that determined that of the 229 pleadings made by the court between 2013 and 2022, only 38 or 16.6% were made by female advocates. And of course, there's been much commentary as to what this means about the enterprise of international law. Is it truly international? Is it truly equitable? So let me ask you, what do you believe is the role of the court in promoting gender equality and bringing in the perspective of developing countries? And ask you again, kind of a follow-up question at the same time. Is there anything you think the court should be doing more proactively?
Thanks, Catherine, for that question. So when I mentioned the responsibility of the court to uphold the values of the UN in its own documents, I was referring in particular to the fact that the court in 2023 completed a revision of its own rules to change those rules in English and in French, which is not easy, so that they were gender inclusive. And it was an exercise that took some time, actually, but the court considered important. And if the ICJ statute is ever opened up, which we don't know if that'll ever happen, because that can only happen, I think, if the whole charter comes open, and there will be lots of things to consider then. But certainly the time is also there for changing the statute as well, which is quite old-fashioned in quite a bit of its language, not only in terms of gender, but also some other objectionable language, I think. What What can the court do? As an institution, I'm not sure that there's much that we can do. But when I've spoken about the need for counsel teams to be inclusive of women and of persons who essentially come from other than European origins, I've tried to emphasize that I think this is very important for all states. I've tried to, I get a lot of questions from when I speak before groups of states, for example, especially in regions, developing regions. I get asked about how teams should be organized. And I always try to say to them, well, you know, it is a good idea for you to make sure you have at least one member of your team who really understands this court. It's not your national court. It has its own peculiarities. You need somebody on your team at least, but don't be afraid to put your own people before the court. It's okay if they speak English or French with an accent. It's okay if they aren't a seasoned advocate. The court wants to hear from the state about its own case. But I also say you should look at your counsel team and ask yourself how that counsel team looks when it's appearing before a world court on issues of interest to the world. And I say this thinking about the fact that when the ICJ engages in its proceedings, especially recently, where quite a few of those have been highly visible, the proceedings of the court appear on television, in videos, on the internet, in photographs, in newspapers. And the photographs don't only show the judges, they show the counsel teams. And the counsel teams should look like teams that belong before a world court. So it's important not only to choose experts, not only to bring before the court members of the state's own nationality, but to ask, well, how can our counsel team be reflective of the views on international law that are held broadly across the world? Now, I want to be honest with you and say that I'm not suggesting that the female judges on the court are more likely to be persuaded if a particular point is put forward in a case by a female advocate. That's not what I'm suggesting. I'm more suggesting that all of us who are involved in this enterprise of applying and developing international law through the International Court of Justice need to keep in mind, no matter what our own backgrounds are, that it is a world court accountable to the world community, and that both the court and those who appear before it should be representative of the world more so than has been the case.
Thank you. So I want to open it, before I open it up for audience questions, I want to ask you, we've covered a lot of ground. I want to ask you to bring together the threads to really say, and going back to our theme, international adjudication, the challenges and efficacy of international adjudication. What are the parting thoughts that you want to give this group?
Well, thanks for that opportunity. We've talked about kind of a selection of topics, and there's more we could discuss, but we can try to sort of tie them all together. And in that regard, a couple of days ago, I was working through some papers that I had, and I came across a photocopy that I had made at a law school library a few years ago. And it's a copy of the edition of the International Law Casebook that was being used at Berkeley, where I attended law school during the period when I was a student, so around 1980. And I had photocopied the 17-page section on international adjudication. So remember, this is 1980. So I took a look at it, and the section starts with what it calls the original dream. The original dream, describing the hopes for the permanent court in 1920. And then it goes on to describe a series of disappointments that were very fresh at that time in 1980. It says that only 6 cases had been brought before the ICJ between 1972 and 1980. And of course, Judge Greenman and I often commented as we looked at the ICJ reports for those periods, if only we had been on the court at that time, our lives would have been quite different. So the book goes on and talks about how there were only 6 cases, and in those 6 cases, 5 of those 6 cases, the respondent didn't appear. So the section concludes quite politely, I think, by saying that the unwillingness of states to resolve disputes in the court has caused concern about its future. So that's 1980. Well, if we think about the busy docket that we've been discussing and the frequency with which states are coming to the court as parties, as interveners, with provisional measures, requests, et cetera, we might say there's a huge contrast to the present time. And we can look not only at the court, but also at the busy docket at the Permanent Court of Arbitration, the docket at ICSID, for example, and the general activity in various forms of arbitration that we can see. So we might say, oh, those concerns about the future of the court, those are something in the past, the future is bright. But I doubt that all of you in this room are in fact thinking that, because there are reasons for caution. And of course, the starting point is the one that Catherine alluded to earlier today, which is there are serious problems in the world outside of international adjudication. And we know what all of those are. In addition, many of those serious problems are finding their way into the court right now. We've talked about some of those today. There's the South Africa case brought against Israel related to Gaza. There's the occupied Palestine territories issue on which the court has delivered an opinion. We have had 2 Ukraine-Russia cases. We have the Armenia-Azerbaijan cases that you know very, very well, just to name a few, and the climate change request that's pending. So what's notable is these are big issues and they are before the court. So in my 3 trips to the UN as ICJ president, I really gained some insights into one of the reasons why so many of these cases are coming to the court. Because I did hear from many states positive comments about the way the court is functioning, and I was of course happy to hear those. But I also heard a lot of complaints about the dysfunction in other parts of the UN family, especially the Security Council. And so a lot of discussion about how there's nowhere else for us to go other than to court. We have serious problems. The General Assembly alone can't move things forward. The Security Council is completely paralyzed, and so states are coming more and more to the court. Well, what worries me about that is, while I understand those frustrations and I understand why they cause states and other interested parties to think about whether the court can be part of a solution, I also worry very much about whether unrealistic expectations for what a court can deliver are being set. And we look at this docket, what's on the docket. We know that there are heightened expectations and enthusiasm, and there's a real question whether, after we look ahead in 10 years or so, how will the court then be judged? Is it really being asked to do things that it is able to do? So I just speaking to a group with a lot of knowledge about the court here and probably as well remotely, I just want to point out that this is just one institution. It's a small institution in an iconic building in The Hague, 15 judges, somewhere around 115 staff only, and that includes all the interpreters and translators. And even if the court can do its job extremely well, it is just a court. It cannot substitute for what might otherwise be seen as executive functions, as administrative functions, as legislative functions. It can't make treaties, for example. It's just a court. And I think it's important for all of us to keep that in mind as we see how these, as the current docket plays out. I think the court, in its own sphere, has been performing well, and I'm optimistic that it will continue to do so despite the constraints and burdens. And certainly the court has been asking, I was asking, and I know President Salam has continued to ask for a sufficient budget to meet the demand that exists. But I'm very grateful to have had a chance to discuss all of these topics about what's been going on at the court and what that suggests for the future here, because here in London, we have not only an enormous number of practitioners and others interested, but also we're in a country that has an especially well-attuned academic community following all aspects of international law closely, but with this particular interest in dispute settlement. So for that reason, I've been very happy to have a chance to talk here with you, Catherine, and before all of you. And when we wrap up, if there's time, I'm certainly happy to continue the discussion with the audience.
Thank you very much. And obviously a lot to think about, and very much, as you say, court may not be a cure-all, but within its sphere and as intended, it's functioning very well. And we have a lot of hope in that. So thank you for that. Let me open it up to questions from the audience, and I'll take 2 or 3 and then give Joan a chance to answer. I think we're getting a microphone over to you. Please go ahead.
Thanks very much. Adam Smith-Anthony from Omnia Strategy. Thank you, Bickle. Thank you both very much for a fascinating and really, really engaging conversation.
Sorry to interrupt. Would you mind just stating your name and affiliation?
Sure.
And stand up,
Adam,
Mike.
and stand up.
Thank you.
Hi, everyone.
I can't see you otherwise.
It's Adam Smith-Anthony from Omnia Strategy. Thank you very much to the host and to you both. I wanted to pick up on Catherine's invitation to revisit provisional measures. And Judge Donoghue, you perhaps gave the court's perspective. I hope it's fair to say, Catherine, you gave the kind of prospective claimant's perspective. And I wondered what your advice would be to prospective respondent states who face the prospect of perhaps being in court within days, perhaps particularly if they're say developing states without a huge well-resourced justice ministry. So just, from the logistics of appointing counsel and figuring out how to get there, are there questions of fairness for respondent states in how quickly, given the issues of profile and law, how quickly they may be invited to come and see the court in far away potentially? Thank you.
Thank you for that. Great question. We'll take a couple more. Anyone? I think everyone wants to hear the answer to that one, maybe. Any questions out there? Okay.
Michael Wood.
There we go, Michael. Thank you.
Question: with the court is really overworked. It's got doing far more than it's ever done before, I guess. And I wonder if there are fears about the quality of the outcome as a result, and the fairness even. Talking of provisional measures, the recent case, Mexico-Ecuador, which was a very small issue compared with some of the other issues going on. But I was struck by the fact that Mexico had half a day. Ecuador had half a day to reply. Mexico had no chance to reply to what we said. And I thought that was rather unfair. But the general question, is it affecting the quality of the outcome?
Thank you, Michael. Sam, go ahead.
Thank you. Samantha Roder, Boys in Plimpton. I will ask the equivalent of the favorite color question. Do you have any advice for aspiring ICJ judges among the younger practitioners in the room?
Lofty goal, Sam. Well done. Think smaller. No, I'm kidding. Anyone else? All right. Oh, please go ahead. There you go. And you'll have to stand up,
Hi.
please. Thank you.
Manuel Casas from 20 Essex and Bickle. Judge Donoghue, was just wondering, do you think the court should be more assertive in declining to issue advisory opinions?
These are all easy, aren't they? So I'm going to pause there. Joan, please.
All right. Well, thank you for all these questions. Yeah, first, thanks for raising the question of the challenges for respondents in provisional measures requests. So because there were so many, I actually had a chart that I was looking at that showed the number of days over many requests in the past, I don't know, 20 years or something. The number of days between the filing of the request and the hearing, and et cetera, all it's sort of a timeline to keep track of those things. The court is required to hear a provisional measures request quickly, but it has always to take into account the need for fairness to a respondent, and that's difficult. It is difficult. I mean, there is some need to appreciate whether something seems truly urgent. So if you look at the death penalty cases, obviously these were well before I joined the court. The president, I think, was acting on his own initiative because of the urgency. There was an execution pending, for example. So the court has to think about that, has to listen to what a respondent might have to say. In terms of advice for respondents, I think that in the world we live in, which Catherine describes as one where there's active discussion, at least, about possible provisional measures requests whenever there's a state that's considering filing an application. Well, if a state is considering filing an application, then the potential respondent also is thinking, or should be thinking, is it possible this will land up in the ICJ? I would be incredibly rich if I had a penny for every statement in which someone at a state has said we are going to the ICJ. They don't always do that, of course, but you know, sophisticated observers can judge whether there's a real possibility that the case might end up before the ICJ. And it is important to start to think about what might happen if there's a provisional measures request, what kinds of requests might be made, what steps could be taken to make that request less attractive, because you can anticipate what kinds of requests might be made, and you can a respondent state can do some of those things before the application is ever filed, or certainly before the hearing. And we see that all the time, that the respondent shows up and says, in fact, there's no need for you court to order XYZ because just yesterday we did exactly that. I see Michael Wood smiling, so he's also, so I have at least two counsels indicating that I'm not making that up, which is good. Quality of the outcome. Well, first of all, the question how many rounds there should be at the provisional measures stage is a fair question. But there's always a situation in which one party gets the first word and one party gets the last. And so it's inevitably, I think, can seem either fair or unfair, depending on whether one wishes to have the first or last word. I think the pacing is in the hands of the court, and obviously has to be made based on many considerations, including the sense that the court may have about whether it really needs to hear from each of the parties in 2 rounds rather than 1. So I think, yes, I mean, the busier the docket is, the more concern there is about the quality of the outcome to an extent. But I will say that the difficulties aren't really so much for the judges. The court operates in drafting committees. For provisional measures requests, it is the president working with support from the president's own team and the registry that presents a draft to the judges. So there's a heightened burden on the president. I think that the risks in terms of outcome, in terms of the quality, may be more with respect to the fact that there isn't a sufficient staff to support the pace of work. And so some of the steps that are invisible to all of you, but are quite important, that go into producing a high quality judgment, require more work from the registry than is realistic with the size of the docket the court has. Aspiring persons who aspire to be on the International Court of Justice. I would say the most important advice, I would say, is don't over-specialize. This is a court that's a court of general jurisdiction, and I'm lucky that I happen to work in a foreign ministry office that's rotational. So I worked, as Catherine indicated, on a whole bunch of different topics, and that helped me a lot. I think someone who comes in who's highly specialized is likely to start really behind the curve on certain cases, but highly advanced on others. Have a thick skin and just recognize that attracting the the nomination for the court is difficult and, you know, can be highly sought after, and the outcomes may be based on things that that an individual has no control over. The election process is a frustrating one. And I would say, as someone who campaigned twice, once unopposed and then once in a contentious election where I seek re-election, the most striking thing about it is the impression that the qualities of an individual candidate don't matter very much. That in the UN, what's really at issue is vote trading. So what I, as a candidate, thought was the most important election, which was the ICJ election, might not be the most important election to a state that's speaking to me. To give you the most graphic example of this not being very much to do with the candidate, during my election, I was seated at one point behind a US flag. That's a standard thing. The person sits behind a flag of nationality with a stack of brochures behind the US flag. And I'm approached by an election officer, a New York-based election officer, who says she has great news for me. She wants to tell me that just before coming, she's been told that she's authorized to tell me and the U.S. mission that her state has decided to support me. So I say, thank you very much. So grateful. Discussion continues, and I realize that she thinks I'm a candidate for the International Criminal Court. Well, U.S. flag, not so likely. So that, I mean, it's a discouraging process. So you have to be prepared to be thrown into a process that may not fit. What was the fourth question then?
Should the court?
Oh, yeah. Okay. Sorry, I wrote declining, but then I couldn't remember what. So I would say no general. I don't think the court should set out any general policy in that direction at all. I mean, if you're referring to a particular case where I took the position that the court should not have heard the case, which was the Chagos case, and only one other judge agreed with me, Judge Tomka. I haven't changed my view on that. I think the court shouldn't have heard that bilateral dispute, even though I think the underlying issues that animated that dispute are serious ones that deserve attention. But I think the court should look at every single one of them as they come in and decide whether it's appropriate for the court to answer, to give an opinion, and how exactly it should formulate that opinion. I don't think it should have a particular policy in one direction or another. It's the court has the responsibility to be responsive to the General Assembly or to other bodies that are authorized to make the requests, and that's really the starting point, I think. Okay.
So just